Native title recognises the rights and interests that Aboriginal and Torres Strait Islander people hold in land and waters under their traditional laws and customs. The following offers a unique perspective on native title, viewed through a window onto the pre-colonial and post-colonial Australian landscape. If we were able to look through a window prior to colonisation, we would see a landscape where Aboriginal people were free to fish, hunt, gather and live. There may be a large meeting or gathering place next to a river. There may be a men's site, a burial site, and places for women's business and birthing rituals. Routes for trade between different nations and language groups, and art and signposts would feature throughout the landscape. These may connect to songlines, complex knowledge systems linking Aboriginal people to their ancestors. Then, European colonisers arrive, and they act as though the land is uninhabited, ignoring the existing rights, ownership, cultural and spiritual connection to land and water held by First Nation people. They may choose the area beside the river for a town and build a pier out onto the water. Roads are built and travelling stock routes reserved for moving livestock. Grazing leases and freehold properties are granted on both sides of the river, so farms now surround the town. A common is created to the north, and the sites where burial, initiation and birthing sites were located are granted as freehold farmland. More reserves are created in town. It is now a very different view through the window. In 1992, the Mabo decision recognised that people were living in Australia prior to colonisation and that they had rights and interests as the traditional owners and custodians of the land. The Native Title Act was passed the following year to preserve and recognise these rights over any remaining areas. However, many things that have occurred on the land cannot now be undone. A highway is difficult to undo. Freehold and other legislative acts cannot be undone. Damage to songlines and markers or disturbance to sacred sites, these acts cannot be undone. These acts have deep psychological implications for Aboriginal people as custodians of this place. Access has been disrupted. The men's site is now on private land and the burial site is fenced in by property. There is no longer access to these areas. The disconnection from land and sacred sites has emotional and spiritual repercussions for Aboriginal people. It inflicts intergenerational trauma and undermines their cultural obligations to protect and care for this country. Through our window, we see areas where native title rights continue to exist, where historical acts have not extinguished native title. Places where Aboriginal people can continue to practice culture and ceremony, protect traditional resources, teach law, customs, and care for and heal on country. Native title rights may continue to exist on Crown land, for example, over parts of the river and on the travelling stock reserves. Native title will continue to exist on the public reserves, although the current use of these reserves may be directly impacting these rights. Looking at the landscape from this perspective helps us understand why native title rights are so important to recognise and protect. Find out more about native title and council-managed Crown land